All right then, I think we'll get started. So thanks very much everyone for joining. I hope everyone is safe and well. So my name is Callum Sinclair. If we could have the slide, Colin. I'm a partner and head of technology and commercial division here at Burness Paull. And I'm joined today by my partner, Colin Hume, who heads our IT and technology disputes practice. Our teams collaborate on a wide variety of technology and intellectual property related matters, but there's been a trend towards working together in the context of today's topic, software audits. And we thought now would be a good time to share some of our experiences and insights in dealing with those matters. This is more on the customer side, generally prompted by customers' receipt of an audit letter or vendor notification of an audit, though we do act on vendor side too, and I'm conscious that we've got a good mixed audience today, so we'll aim to touch on the subject matter from the supplier's perspective too, but predominantly coming at it from the customer side. But don't let us off the hook. Do pick up with us in Q&A if we don't cover anything you would like us to. So our plan today, if we could have the agenda slide, Colin, is to start by exploring what the issue is and why software audits are a growing trend. Colin will then run you through a typical case study based on our experience of advising clients, and we've picked one example which is loosely based on one where we were both involved in acting for a UK PLC customer and able to secure them an exceptional result, a new licensing deal which was fit for purpose and an approximate 30-fold decrease in the additional license fee payable for the disputed period. And we'll finish with some insights and tips, including when you're drafting audit clauses and around managing the audit process. Slide please, Colin. So let's start by saying that and acknowledging that it's entirely fair that software audit rights exist, whether in a more traditional software licensing model or software as a service. Vendors will have invested significant sums in research and development and product development, increasingly with DevOps, a continuous development and investment cycle, and they only receive a return on that investment when they recognise revenues from commercialisation of their products and services. Historically, even with digital rights management and other technical countermeasures, software license breach has been an issue, though in a corporate sense, this has often been due to poor license management practices rather than intentional malfeasance. There has been one key factor, though, which has brought the issue to the fore now more than ever, and that is the rise of cloud computing. As part of their digital transformation journeys, organisations are increasingly moving parts of their IT estate off-premise and into the cloud, leading to a hybrid of traditionally licensed software with a blend of software as a service and platform as a service solutions. We see most problems arise when organisations have made that shift from traditional to virtual without updating their contracts and their license and use rights to reflect the new reality. There are other market dynamics at work here, though, as a result of increasing migration to cloud technologies. The rapid rise of cloud has left many traditional enterprise vendors like SAP and Oracle, for example, with the enormous challenge of trying to pivot their businesses and their product sets to compete with a newer breed of cloud-first vendors like Salesforce, for example. Major strategic integrators too, like Atos, Capita, Capgemini, Wipro, others, are facing similar challenges, with a move away from enormous bespoke IT outsourced projects involving traditional software licensing and support models to hybrid ecosystems involving the service integration and management of a variety of cloud-based microservices. And this is driving some predictable behaviours from enterprise vendors in particular, who are, let's face it, doing their homework on customers and developments in their customer businesses. We've seen a significant increase in recent years in software audit rights being invoked by vendors. And this isn't only to maximise revenues from ageing legacy offerings, but it's also to help with the substantial investment and costs necessary to pivot the product set to a cloud offering, to market that to existing and to new customers, and to fund the new skills, processes and training necessary to become a cloud-first vendor. Before legacy products move out of support, there's likely to be a period of parallel running, and that could involve some duplication of costs. So it's perhaps not surprising that vendors are being more aggressive in enforcing or seeking to enforce software audit rights. There are other factors beyond migration to the cloud and digital transformation which have led to customers losing control of their software assets. Disregarding any intentional breaches, corporate transactional activity, for example, sometimes leads to a differently profiled user group, and perhaps a merger which has resulted in a larger user base, or a divestment of a business or function which leads to a different shape of requirement. A change in key personnel, for example, senior IT personnel, can also lead to a lack of knowledge and control over software assets. And so can a change of outsourced IT provider if the scope of services includes license management. Of course, software asset management systems should be in place to deal with this, but too often we see that such systems are not fully implemented, are not fit for purpose, or somebody somewhere has a spreadsheet where the details are maintained. No surprise then that the software asset management market has seen a steady growth. It was valued at $1.16 billion US in 2017 and estimated to grow to $2.32 billion US by 2022, so a near doubling in 5 years. And the frequent changes in licensing rules, coupled with the difficult to understand license metrics definitions and software contracts, are just some of the key complexity factors which make software asset management SAM an expert service. And implementing SAM processes can effectively mitigate the financial risk associated with inappropriate use of software, and according to those in the market, reduced by up to 25% the cost of associated with software licensing. There's also been a trend towards vendors engaging third-party audit companies to conduct audits on their behalf. For example, the Big Four accountants here in the UK. It's likely in many cases that these third-party auditors will be incentivized to uncover unlicensed software use and to maximize recovery. And this approach has a number of advantages for a vendor, as well as not distracting from its core business. And it also allows a degree of distancing between itself and a customer in a scenario which could involve some difficult conversations and potential dispute and enforcement activity. Large corporate customers who perhaps had been able to rely on their buying power with vendor sales teams might now be having to engage in much less comfortable discussions with third-party auditors. The area that clients often come unstuck is that legal documentation falls behind IT procurement activity to update the IT estate. License management is often seen as the responsibility of IT teams, whereas in practice, particularly for larger organizations, disciplined engagement of IT procurement and legal, internal or external legal teams is often required to ensure that contracts line up with reality. Of course, there needs to be a balance where legal documentation is flexible enough to allow scale up and scale down of requirements so that there isn't a cottage industry in contracting. However, there's rarely that flexibility to shift the entire basis of licensing or to make fundamental changes in how license compliance is measured or license charges are calculated. Too often we see layered license addenda, short form variations, change controls, informal side letters or statements of work are used inappropriately to document more complex changes to the nature or basis of licensing. Even where these do reference the master licensing documentation, and they don't always, there's rarely much consideration of what that documentation says or whether it's anticipated the scope of licensing changes proposed, as opposed to, for example, small changes in user numbers or additional modules. Finally, the picture can be further complicated by the proliferation of open source software and the many and varied OSS license types on offer. Software is increasingly built in a modular way for speed and efficiency and to avoid reinventing the wheel. There are a number of developer libraries offering free-to-use modules, even where there will be commercial exploitation. But there are tripwires along the way, licenses which are viral and can attach to and require the open publication of code, source code, to which they attach, or which contain other unusual onerous license conditions. Open source licensing isn't an area we'll go into in any detail here. We've given separate sessions on that. But suffice to say that caution must be exercised by development teams, internal and external, to ensure that any use of OSS is well understood and documented, and that appropriate assurances around use by third-party vendors are sought. There have been some high-profile enforcement and audit actions, particularly in the US, where OSS license terms have been breached, particularly the Free Software Foundation. So the overarching message from this first section of the presentation is that it's easier now than ever for customers to get into difficulty in software licensing and software asset management, even where there are good intentions and some processes in place for license management. So I'm going to hand over to Colin now, who's going to look at the dispute side a bit more and take you through a typical license audit dispute story.
Thanks, Callum, and good morning, everybody. As Callum said, Colin Human, I'm an IP and tech litigator, and Callum and I tend to team up with these issues and disputes because there's some very distinct skill sets that I think are needed to ensure that clients have the best support. As he said, we're more typically involved from the customer side. I think very often larger vendors tend to manage all of this in-house or with consultants who support licensing programs on a global scale. However, I would emphasize that this is a slight change of role for me. Use of software without permission or a license is copyright infringement. That's the case whether or not the use was intentional. And we more typically act for rights holders in enforcing intellectual property rights. For example, we handle copyright enforcement programs for Sky, PPL, PRS for music, all across Scotland. So I've got every sympathy with the software vendor who's thinking, you're using my stuff and you're not paying for it. So I get that. This flow chart shows the story of a software audit dispute which Callum and I worked on recently. Callum's already touched on this. Our client was a UK PLC who instructed us following an audit by a Big Four accountancy practice. The outcome of that, and the letter was saying that our client owed the vendor in excess of $30 million. That's an additional $30 million onto what they were already paying. They hadn't budgeted for that. Clearly, our client, bearing in mind that the kind of numbers are involved, you're probably realizing that our client was already a large and important customer to the software vendor. But that didn't cut it. I mean, I think they thought they could rely on their purchasing power and the relationships that they had with the vendor, and that would get them through trouble. They may have to pay a bit more, but they wouldn't be hit with a $30 million claim. Unfortunately, their account manager, I mean, clearly the vendor had anticipated this. The account manager was moved away and just had no authority to support them. And the license and compliance issues were being handled by a more senior manager who had a very laser sharp focus on making sure that the account was regularized and they weren't able to exploit their buying power. So my part of the presentation is going to be loosely based on this case study, having taken care, I certainly hope, to preserve client confidentiality. The very first thing your IT director is going to be saying was, why on earth did this happen to me? It is probably, in one sense, a futile question, but nevertheless one that is going to be being asked. In our case, I think we thought that there was a specific person in IT who had a very good understanding of the client's estate and may well have blown the whistle and reported them. If it's very easy, with a very quick bit of searching online, you can find plenty of opportunities to turn in companies who are suspected of using software unlicensed. These are some forms from Microsoft and FAST and British Software Alliance. They do tend to differentiate between counterfeiting and simply, unlicensed or under-licensed software. So there is a degree of sophistication. The report can often be made anonymously, and there is a financial inducement, or there can be a financial inducement to getting a positive hit. So there's every reason why, if you have a disaffected employee or former employee, that there's certainly opportunities to make difficulty without any comeback on them. So this slide shows just some of the other ways in which this can happen. Through mergers and acquisitions, employee data and financial data numbers that are all being publicly available information, these are being monitored. I would expect corporates who are large users of software will be issuing press releases announcing mergers, growth in employee numbers, and turnover growth. And that is going to be picked up by your software suppliers. In our experience, this tends not to be an issue for SMEs. Certainly, we haven't been acting for many SMEs facing these problems. The bigger you are, the more likely you are to be higher up the audit list. So each of these events are going to probably, your vendor will realize that there's a need for increased licensing if you've grown employee numbers and you've grown turnover. And their compliance teams are going to be looking out for that. And they will be expecting an increase in license purchasing, or they'll be wondering why. Even without relationship managers being given updated information, software suppliers' algorithms will provide predictions as to your likely license need. If your purchasing is out of kilter with that analysis piece, then they're likely to be due an audit. We've already touched on whistleblowers, and also there's also just simply your name just may be up. There may be routine or random ongoing compliance program, which means that you're likely to get an audit request. So the audit request is received. We've already got over the trauma of why is this happening. We just accept that we need to suck it up. Don't start pouring your heart out to whoever has written the letter to you. I think, first of all, I would be checking that it's genuine. And obviously, you'd be using information you can independently gain, or contact information that you have from your software supplier to make sure that the letter that you've received is actually a genuine one. This is a great opportunity for, if you're feeling vulnerable, for somebody to commit fraud. So just at least be aware of that before you go down a route you don't want to. Depending on the position you've got and the relationship you have with your software supplier, assuming your account manager hasn't run off, you could suggest a self-audit. A self-audit which perhaps could be certified. This could be done by either your own internal team, or you could engage consultants. This removes a lot of the difficulties of an external audit. We're going to go on and discuss that clearly. But if suitable verification is produced, then it may satisfy your software supplier that all is in order, without their having to incur the expense of conducting the audit themselves. I mean, I think providing certification here is key. I mean, there could be a wry smile about we'll check ourselves and let you know it's okay. But if you're either offering a Big Four accountancy practice to verify everything's okay, if you're even offering a director or somebody at senior level in your organization is going to sign off on the audit, something you need to think carefully about, but nevertheless, there are ways of doing a self-audit and providing self-certification that may well work. The next thing to think about is look at the letterhead from the letter you've received, if it's actually a letter, and who's running the audit. I would have different levels of concern depending on who I got it from. If it's from the vendor's licensing team, for a SAM consultant, Big Four accountants. If they open with an IP litigator, I'd probably be more worried. And of course, you can check that. So it's worth having a look at just exactly who you've got who you've got this from. Of course, I don't need to tell you that you should acknowledge receipt of the genuine request, but anyone requesting the audit is going to have to accept that you will have ongoing operations, and you should do all you can to buy some time here. I mean, the audit will, presumably they've got rights to do it, and the audit will need to go ahead, but it should be something that can be fitted into your planned work program. There shouldn't be an absolute urgency for this, and you shouldn't disrupt other more time-critical work simply for that to be done, and that needs to be part of the negotiation. Depending on what the audit clause says, that there should actually be some room for manoeuvre here, and you should make sure you use the most of that. But in saying that, one thing to absolutely underline, and perhaps it goes without saying, is don't start deleting stuff. Certainly, deleting information which might be needed as evidence should a dispute later develop would be a concern. If you have, you will have an ongoing program of data destruction after so many years, then you really should seek legal advice before deleting any relevant data which might be relevant to the audit once the request is received. It's receiving the request, and if there perhaps is an issue for concern, that even your ongoing routine data destruction process may be an issue if you're now knowingly deleting information which may be relevant for the audit if there's issues of concern here. So moving on, the internal contract and usage review. So what we've got the audit letter. We've probably pulled a team together of people as to work out exactly what you want to do. Perhaps depending on the size of your organization, it'll be senior people in your IT team, legal, and whatever else. It's really important not to create evidence which is going to be of concern. It's very easy at that initial stage to start sending out WTF emails, perhaps, I'll be polite, holy cow, we're in it up to our necks type emails is not good. Bear in mind what you say on the phone can't be later disclosed in court. So actually, if you need to get that off your chest, I advise you to do that by telephone and not leave a trail of evidence. More seriously, if you're starting to look into the problem and how to respond to the audit request when you're getting your sleeves rolled up, you do need to think about what information is being exchanged. Look, we could have a whole separate presentation on the issues of privilege and what you can and cannot say, and anything that you do say can create a problem further down the line, or would at least be a concern. Because if you do create a body of information which is really damning of your company, if I later become involved and I'm looking at that and I'm saying, well, we just can't end up in a litigation situation, not necessarily because of what's gone on before, but because of what's been discussed and what's been said. If that comes out in court, it would be damning. So at the risk of sounding like I'm making an overt sale, which I am, if you do engage lawyers in this investigation, then they will be able to ensure that it's legally privileged. And if a lawyer is heavily involved in it, then legal privilege can cover the investigation, the internal review, and that's something which should be borne in mind. There is another justification for keeping information like this out of the public domain, which is information prepared in contemplation of litigation. But I don't think we're at that stage yet. I think it would be difficult to say you've got an audit request, you're doing an internal review. I don't think you can say that you're seriously contemplating litigation. At least I hope not. So that wouldn't be great. Next off, perhaps even before you get into any of this, check what the contract actually says. That's really important. Maybe they don't have audit rights. Maybe it's an older contract, or the audit rights aren't enforceable or aren't that strong. In the case study that we're working through here, Calamine, there was a real legacy of software of software contracts going back, I think, over 10 years. Nothing had been signed. Everything was in draft. It was really unclear which appendices applied. It was an absolute mess. Things have been updated as they went along. Amendments from one year didn't really fit into the amendments from the previous year. So we were trying to piece all of it together and to work out exactly what audit rights existed. And certainly if you're in that situation and if you've got a $30 million claim you're handling, then probably best to certainly have lawyers supporting you. You should look at what's going on internally in some way. I think being blind to it and saying let's not look and let's just let them come in would be risky. And you do need to assume under licensing. Certainly, if you've not done an audit recently or had an audit done recently, it would be assumed that there will be, or unless you've really over licensed, it's probably likely that you're under licensed. There's a 2018 Flexera report. Found that 75% of companies were out of compliance with their software licensing, and of that 75%, 20% of them ended up paying more than $1 million to regularize the license position. So really building on what my point about the contract, ensure you have a clear understanding of what the audit rights exist. When you get to engagement with the whoever's providing the audit, I think it's really important to have clarity that you all have agreement going forward as to exactly what audit can be done, and that's absolutely important. And as I mentioned, in our case, our client's account manager disappeared, but it's certainly worth ensuring that your account manager is aware of what's going on. I think that there may be scope for this to be managed in a supportive or friendly way, but it's certainly important to make sure that they at least understand what's happening. So moving on, get to the conduct of the audit itself and what's actually gonna happen. You need to make sure you get non-disclosure agreements or data sharing agreements in place. That can take some time. So back to my earlier comment about your IT team having to absolutely drop everything to comply with an audit, and just, you get the letter in and the next day you got people turning up at your door. That's back whenever people actually could go into premises. But people would say we're turning up next week to do an audit. I think I would say somebody needs to put their foot in the ball and say, let's just stop and let's have everything agreed before anything happens. You're going to have to get your NDAs in place, data sharing agreements in place. There will be GDPR issues in terms of information which is potentially being accessed. Clarify lines of communication. If you do have an audit response team in place, there should be a very clear nominated person who would be the only person, or perhaps with a deputy, the only person who should be the point of contact for the auditors, and make sure that that's clarified. At that stage, you may want to agree the interpretation of license terms. So there's a good understanding of what they are looking for and what you've done. This team should ensure that you've got appropriate internal resource which can be allocated. And again, that's an issue for this not being done urgently. The auditors will want to do this very quickly. There's every likelihood, if they've sent the audit request, they've got resource, they've planned for this, they've got resource to come in and do this really, really quickly, and that's going to be in their interest to do that. There is no prejudice to them if this takes some time. You're not going to be deleting information. I doubt that anyone's going to need that confirmed, but that would be the case. So the status quo will be preserved, and I think this should be done in an orderly way. You need to agree the remit of the audit. Which systems can they look at? Platforms. What level of access are they going to be allowed? How long should the audit last for? You don't want them there forever. Which group companies are included in which physical locations can they look at? So there is a great deal to be sorted out. Very often the audit clause won't cover off all of this stuff. Now, I would recommend that it's necessary. You have to comply with this, but I'm sure there's a way of doing it in a pragmatic, reasonable way without simply rolling over and just giving them the keys and saying, have a look and let us know how bad things are. You should dictate the pace is really the takeaway point from here. and do what you can to keep control of the information flow. Another good reason to involve lawyers is you can just involve us and just blame us for slowing everything down. Always happy to do that. So you've gone through the audit, and the dreaded day of the audit report is then issued. So you've got that, and you need to work out what to do. And this is where we came in with this, the case study in which our clients had found that they had apparently under licensed to the tune of over $30 million. Again, my message is would be take some time, don't panic, and agree a response timescale. They may have spent a month or two doing this audit, I don't know, maybe weeks. They'll want the response within 7 or 14, well, not quite 7 days, but 14, 21 days. There is perhaps no reason for that. And again, the world is going to keep turning, and I suspect you should take your time and just make sure that you've got an appropriate timescale to respond. You should challenge. I don't mean you should challenge everything that has been assumed in the report. I'm not saying unnecessarily, just find ways to challenge things unreasonably, but don't accept assumptions which have been made and bring your own fresh approach to it. If you've not done your own if you've done your own internal review, you've got something to compare it against, or perhaps you would have some sort of bespoke internal review at this stage to check and challenge the audit report that you've received. At this stage, you could perhaps try and engage to see if there's another way of resolving this. We're going to get on to looking at potential resolutions, but do you have future software needs that you could try and bring into this discussion? And you should definitely prepare a comprehensive response, looking at all of the potential defenses or arguments that you can make. Contractual, technical, commercial, legal arguments. Commercial being particularly your future buying power is really important. In the case of this case study, over a long period of time, we were able to show that our client had been completely open book with their supplier's account manager, and their ongoing purchasing of software had been made against the backdrop of their account manager having full knowledge of their move to the cloud, and that this was going. In fact, the account manager had advised on our client's license needs and been part of the purchasing decision making. We were able to show really strong evidence of this, and actually of knowledge and activity of former account managers that had left the supplier. So we knew that the supplier had some difficulty in investigating it from their perspective, and there was definitely some real vulnerability. There are legal arguments of personal bar and waiver that we can deploy. Your software license will certainly try and limit those as best they possibly can. But if, in fact, there's very much a commercial argument to be made here that if a senior enough person within the software vendor organization has been sitting around the table working with us, spending millions of pounds in buying software, knowing exactly about our virtualization program, it's quite difficult for them to come in and then say, "Well, forget about everything that we knew, and you owe us all of this." Certainly, without a degree of a red face on their part. One of the discussions we needed to have was what accounts provision needed to be made for this. As I said, they certainly weren't ready for a $30 million hit. Actually, and this is really an important point to be made at this stage of consideration, is that very often the numbers coming in are really high, and in every one of these cases I've had, they start off with a really big opening number. If it was me, I don't think I would come in with such an unrealistic number. From get-go, Callum and I looked at this and said, this isn't $30 million. I think we advised on a provision of about $5 million. We thought at worst it's 5, perhaps it was 7 million. We thought that it was a range that there's potential exposure, and 30 million actually undermined the position of the audit. That just didn't stand up. However, we thought there was a significant claim, but our arguments were really coming down from that 5 to 7 million range. And in that case, we had some difficult discussions about making sure appropriate provision was made in the accounts. Then looking at the dispute resolution process. So I mean that in the broadest in the broadest sense. So you've got the audit report, you've done your own analysis, you're then engaging with the auditor, or perhaps at this stage it's the vendor, to work out exactly where you are. And when I mean dispute resolution, I clearly don't just mean litigation, as you can see from this slide. Very often, the top left is going to resolve matters. It's simply going to be a commercial negotiation, and you will try to resolve things and reach a sensible understanding. There are many other ways in which you can do that. Dispute escalation process may well be built into the contract. If it isn't, that perhaps could be agreed to say, well, we'll try and do what we can, but we want this to be escalated to different levels within management. Very often there's specific issues, which perhaps legal or technical issues, which might usefully be resolved. If there's something fundamental which someone says it's black and someone says it's white, then you could very quickly go to an expert. Just find an independent expert to send this to. It doesn't involve all the delays and expense of court, but you can simply say, okay, well, this is something which is just so fundamental to whether or not we owe you 30 million or we don't owe you anything. Let's get a third party involved. It's risky if you have it make this determination binding, because there's probably no appeal to that. So if you say, okay, well, if we send it to Callum and Callum tells us that white is white, then we will have to go with that. The other way is to say that Callum's position is non-binding. Obviously, the downside of that is then whoever loses on that may then disregard that, so it's of limited value. But expert determination is a very quick and ready way to move things on. Mediation, again, is often built into the software contract, or should be increasingly so. Mediation, for those that don't know, is really just a facilitated negotiation. It's just a third party will come in. Typically, it can be resolved dealt with in a day. It's just a negotiation with the third party facilitator. They will make no judgment on matters. Their focus is to help you get to a deal through shuttle diplomacy or whatever, and it's non-binding unless you get a deal at the end of the day, and ideally you'd sign that up at the end of the mediation and resolve things. So I'm a big fan of mediation, a lot of success with it, and even doing using these virtually. I've got a large IT dispute which is going to a virtual mediation next Friday, involving parties in Australia as well as in Scotland. So it's mediation is very, very effective. Arbitration is very like private court. At least things are kept quiet, but it's pretty expensive because you've got to pay for everybody, and the judge is not cheap. And then of course litigation. Relatively few litigations come out of this. Callum's alluded to some, particularly in the States, but it is unlikely. Things have gone really badly wrong if you're going to end up in litigation. It's important to bear in mind, though, that what would happen, and that perhaps would be the backdrop even to negotiation. If you think, well, we're going to be litigating, or if we don't resolve this, we're going to be litigating, and just thinking that through. If you're based in Scotland, there's a very good chance that they would have to come to Scotland to litigate, and that's probably not part of their thinking. But is this actually a contractual dispute? Can they be relying on the software contract? Does it provide for under licensing? They don't always do so. Very often, it's actually a case of copyright infringement, and the contract really flies off, and it's a straightforward case of have you infringed their copyright and where have you done that? And if you're based in Scotland, the chances are that's all here. So that's to be factored in. At its most extreme, you can apply for an interdict or an injunction to stop the ongoing copyright infringement. The chances of them getting that on an interim basis at the very start are negligible if you're running your business on this software. But it's something that may be thrown about. And so really the final slide here, the final point I want to touch on is the resolution. We've in every case that Callum and I have worked on in recent years, we've always got to we've always been able to achieve a sensible commercial resolution. This is a stage when you really do want to look at what your supplier wants. There is a danger that a lot of these, or some of these SAM service suppliers, or perhaps some of the big four accountants, may be incentivized by the amount of recovery. I don't know if that's going to be a factor in their thinking. But you really want to work out what the supplier wants, and they will want to increase their revenue. Does that need to be in the short term? Is that medium or longer term? So actually just having a proper understanding of that. The deal needs to be an absolute deal. You want to draw a line under this. All of your group companies, you don't want them then turning up and going. You reach a deal with John Smith Limited, and then John Smith Glasgow Limited gets an audit request letter the next day. You've got to make sure that it's covers everything. Perhaps you factor in future software purchases. Perhaps if you are paying more, try and get some training or support packages thrown in. That may be a soft give for your supplier. And it's really key that you get confidentiality agreed. You do not want, depending on the outcome, you don't want the software supplier dragging your name around the streets, suggesting that look what we did with John Smith Limited, we're going to do it to you as well. So whatever the outcome, it's really important that is kept confidential. Again, that should be an easy give for the supplier, and if it isn't, then you should be concerned. So that's largely the story of the audit, rather difficult audit dispute we had. I should say the end of our story of it is that through Callum and my teams collaborating, we actually went from the $30 million claim to effectively no payment being made. We did have to increase some purchasing, but I think it was low millions. Callum may well remember the actual number, because when we get to this stage, it's really important to have a much more sophisticated agreement put in place and ensure that everybody knows where they stand going forward. And that is the stage in which Callum would lead. Once certainly the overall dispute is resolved, Callum's team would step in and tie up all of the more detailed, sophisticated contractual arrangements to make sure that if this happens again, everybody knows where they stand, and perhaps to prevent any future disputes at all. So I'll pass you over to Callum.
Thanks very much, Colin. Yeah, I think it was about the original claim. I think it was about $31.5 million, and I think the final payment was around $1 million, but that was largely to account for new software being licensed. So that was a great result for the client. And as well as being beautifully cued by you, I've also been cued by a question in the chat function. So thank you very much for the contributor of that question. Really just looking for, I suppose, tips and tricks and what can be done in advance, really, to address some of these issues up front. And that perfectly cues the last section of the presentation, which is around, what is the call to action, and what should you do now? So if Colin, if you could advance the slides. Whether you're coming off the back of a dispute or no, ensuring that your software contracts are fit for purpose is a great start point. And there are many facets to robust software agreements, whether they are traditional license agreements or cloud service agreements. In traditional software licensing, that might include escrow, It might include new versions and releases as part of maintenance, software warranties, IP indemnities, and so on. And with cloud contracts, maybe it's more availability and uptime commitments, security and handling of remotely hosted data, and flexibility to scale usage up and down and to terminate at short notice. A clear, well-understood basis for licensing or use, ideally with some flexibility built in to deal with foreseeable future-proofing, excuse me, is important for any software contract. We don't have time to go into all of the other requirements for these agreements in any more detail, and again, we've separately presented on those issues. But let's focus on, I suppose, purely a software auditing perspective. As a supplier, you would want to ensure broad rights of access to customer premises, information and data, customer personnel, for both your organisation and any third-party auditor that you appoint. You would want notice requirements to be minimal, to have the option for audits to be conducted possibly outside as well as within customer business hours. And you would also have provisions in there allowing for immediate invoicing of any additional license or usage fees due, and possibly a contribution to the costs of audit, up to potentially 100%, where non-compliance was uncovered. From a customer perspective, you'd be looking to narrow the audit's rights to what's absolutely necessary to confirm compliance, to build in plenty time to complete an audit, as Colin mentioned, with plenty of supplier notice required and limited direct access to personnel and to systems, possibly chaperoned access. Ideally, you would want to limit the frequency of audits to, for example, to say once a year or once every 2 years. And you would also look for assurances that the audit would not interfere with the conduct of the customer's business, and to build in some GDPR and Data Protection Act 2018 protections in respect of any personal data that might be involved or be uncovered incidentally. As an aside, it's worth bearing in mind for cloud providers that there may well be some reverse audit rights for customers which might be offered or negotiated into your agreements. Particularly in regulated sectors like financial services, regulation will require, and guidance will require this. That can present its own challenges for audit in secure data centres from which many customers will be receiving service, and confidentiality and security are paramount in those circumstances. I suppose the next tip is that deploying technical measures to manage software assets is key, even if you're a relatively small business. If you are a smaller customer business, it might simply be putting in place appropriate procedures, renewal processes, and diary checkpoints to ensure that the position on the ground matches that reflected in the contracts. For a business of any scale, that's more likely to mean deploying software and asset management systems which are up to date and are capable of proactively managing both cloud and locally hosted software and some of the complexity that Colin has talked about. If you're a vendor, you should already have CRM processes in place to check in regularly with customers, usually for the upsell. If you have support and maintenance contracts, then they will also provide natural touch points for working with customers. And you might also have digital rights management, DRM, network monitoring, or other technical countermeasures to help ensure compliance on the part of your customer base. It's also critical for cross-functional teams to share understanding and responsibility of an organisation's software landscape. This is not simply the preserve of IT professionals. IT specialists will have a deep understanding of the technology and how it operates and interfaces with the wider IT estate. But procurement and legal colleagues will bring their own perspectives, balancing value for money, technical requirements, risk management, and compliance. In particular, all too often we see lawyers, both in-house and external, shy away from increasingly complex and varied IT ecosystems. And it's essential for us to get under the bonnet with our clients if we're to provide best service. It's of particular importance to understand the key differences between the typical licensing and service models which apply to on-premise or traditionally licensed software. Cloud agreements including SaaS, PaaS, and IaaS, and open source licenses. For example, are they licensed on a named user basis? Is it concurrent user instances? Is it by CPUs or virtual machines? And one thing that caught one of our clients out was software that was licensed per the original license documentation, which dated back to the 1990s, on the basis of a number of machines, which the client took to mean physical machines or CPUs, but what the vendor interpreted to mean virtual machines, where the client has migrated to a virtualized infrastructure over time, and that resulted in a large potential liability. Another important step is to consider the establishment of self-audits or mock audits. In the same way as you might have in place procedures to test business continuity and disaster recovery of ICT systems, or white hat consultants mimicking a cyber attack to test response, it would make sense to set up regular mock audits involving those cross-functional teams to ensure compliance and take preemptive action. Take advantage of regular touch points with vendors to ensure that paperwork is up to date, and beware of bolt-on addenda if the underlying documentation isn't really fit for purpose. Finally, we would always encourage organisations to ensure that they seek expert legal advice before doing anything. That can, of course, be from in-house counsel or externals. And there are many good reasons for this, some of which we've touched on today. Allowing unfettered access for vendors, even if the contract contains broad audit rights, can create serious issues around security and confidentiality of other systems. It can create GDPR and data privacy issues, and not to mention evidentiary issues which could compromise the organisation in any follow-up action. And that, just to emphasise, particularly for the vendors on the call, that's not necessarily that the customer organisations may have anything to hide. It may simply be important that appropriate limited access is granted and that raw data consequently gleaned is properly contextualised, rather than it being simply a fishing expedition, particularly with a third-party auditors involved who might have other incentives to find other unlicensed use. The involvement of lawyers can also afford critical protections around legal privilege, as Colin's mentioned, and which can be absolutely key in a disputes context, and which is not necessarily available elsewhere. And just on that slightly repetitive and self-serving note, I think we can probably wrap up now for questions. So if anyone has any questions, please do take yourself off mute, or you can use the chat window, and we will look out for those coming through. So would anybody like to start us off and save us from the even more awkward by webinar than in person tumbleweed moment for a first question?
Okay. Can you hear me, Callum?
Yes, I can.
Hi, Callum. My name's Nick Tubby. I actually work for BT, and I'm a software licensing specialist. No, I'm just curious. Do you think that with the potential of COVID causing a bit of a aside from Microsoft Teams, I think a lot of software vendors are going to have lost a lot of revenue. That they will use this audit path as a channel to make up those lost revenues?
That's a great question, Nick. Thanks for that. I mean, I think at the moment there's a lot of distress generally in the technology sector, although obviously the impact that technology can make on COVID is potentially significant. So there are some things there. I think anything that will help to bolster revenues at this challenging time will not be off the table. Having said that, there are long memories, and we know that from global financial crisis that poor vendor behaviours at this point potentially could rest in the minds of customers going forward. So I think there will be a balance to strike, Nick. I think very much be an increased and heightened awareness of any unlicensed use, and certainly a commercial consideration around, I suppose, balancing going after customers for that to get a potential short-term hit or win versus the longer-term relationships, which will become, increasingly important.
Thank you.
Thanks, Nick. Conscious we're at 10:30 now, so we are almost out of time. Are there any last questions before we wrap up? No. All right, and I hope we've answered the question on the chat function as well there for folks around key tips and takeaways. But do feel free. Our contact details are on the screen at the moment, so if you do have any follow-up questions you'd like to ask, we're both on LinkedIn, and our contact details are on the screen for you now. And obviously, we will be circulating a recording of the webinar after this. So please do feel free to follow up. And I think it probably only remains for us to say then, thank you very much indeed for everyone joining today. And on behalf of all of us at Burness Paull, to keep safe and well. And thanks again.
Thanks very much.
Thank you.
Thanks, everyone.
Thank you.
Thank you.
Thank you.